organization.
It's just late.
All right, welcome to the our Alarm Systems Contractors Board meeting. We will call our meeting to order. Cody, if you would like to have a roll call for the record, please.
Thank you. Scott Cockcroft.
Here.
Keith Harvey.
Here.
Vivian Hickson. Karen Jones. Here. Mackenzie Robert.
Here.
Let the record show that Vivian Hickson is not here, but you do have a quorum.
Good, thank you. First item on our order of business would be the agenda. I believe the agenda was set out in advance. There should be a copy of it on your iPads. We would, at this point, entertain a motion to approve our agenda for the day.
Make a motion to accept the agenda as presented.
Second.
We have a motion and a second. Is there any discussion? All in favor, if you'll signify by saying aye.
Aye.
The motion then passes. Thank you. Our next item of business would be the minutes from our previous board meeting. Again, they were sent out in advance or made widely available. Were there any corrections or comments on the minutes, or are you ready to approve those as they were presented?
Motion to approve them as they were presented.
We have a motion. Do we have a second?
Second.
Okay, we have a second on the motion then. Is there any discussion? All in favor, if you'll signify by saying aye.
Aye.
And that motion then passes. That was unanimously. All right, next item on our business would be our legal report. We ready for our legal report?
Yes, good morning. My name is Matthew Reddish. I am the new disciplinary counsel for this board, taking over for Shalina. This will actually be my only meeting, though, because I'll be leaving the department on the 25th of August. So this will be the only time that we get to meet. But most of these cases on the legal report are mine. So if you're ready, I'm happy to start.
Yes, I think so. Let me get to the report on my pad here. All right, if you will proceed then.
This is my first time before you, so just let me know if I'm not doing something the way that you generally like it done. Case number 1-2017030351. The summary on this case is as follows. The complainant alleges respondent engaged in deceptive acts when they misled her. As to the fees they would have to pay in the event of cancellation or complainant moving residences. Respondent states all fees were agreed to in the contract. However, this time, respondent will agree to allow complainant to cancel the contract without penalty. Legal spoke with the complainant, who stated they do not wish to pursue this complaint further at this time, and that respondent has not attempted to collect any additional funds from her. Recommendation is to close.
Make a motion to concur with counsel.
Second.
We have a motion to concur with the recommendation in council and our second. Is there any discussion? All right, all in favor of the motion, if you signify by saying aye.
Aye.
Any opposed? Motion then passes unanimously. Thank you.
Case number 2. Case number is 20170381111. Summary is as follows. Complainant alleges respondent violated their contract when respondent failed to refund prorated annual fees upon complainant going out of business. Respondent asserts the contract does not require this refund but is willing to refund the money anyway. Complainant in the rebuttal states that while contract does not require this refund, it was promised to him orally. This is ultimately a contractual billing dispute. Legal's recommendation is to close.
Who's what we normally do there?
I'm not sure that I understand. I'm still trying to find the notes here in this iPad.
You need some assistance there, Mr. Chair?
Thank you. Yeah.
Go over to the library now. There you go. Just
I'm not sure that I understood your recommendation. Did I understand you to say that the respondent was offering to make a refund even though that was not a contractual obligation they had?
That's correct.
All right. Thank you for that clarification. Do we have a motion?
I'd make a motion to concur with council's recommendation.
All right, thank you. We have a motion and a second. Any discussion? All in favor, if you'll signify by saying aye.
Aye.
Motion then passes unanimously. Thank you.
Entry number 3, and I misstated some things on this. I reviewed it again this morning, so I need to make some corrections. The case number is 2017-040171. The summary on this case, the complaint was that there was a van driving around town that did not have a license number on the van. And when I originally read the complaint rebuttal, I thought it was an unlicensed activity complaint, not a violation of not having a license number on the van. And from all the photos attached, it does not appear that there was a proper license number on this van. And then the remaining part of my summary will be as follows. Complainant took a picture of a van with a sign that stated SDI and then the slogan below, security/technology, but could not find a license number to match a company named SDI Security. A complaint for unlicensed activity was filed. In its response, respondent SDI Presence stated they recently acquired SDI Solutions and believe they could continue to operate under SDI Solutions license. Respondent states that if they engaged in any unlicensed activity, it was inadvertent. Subsequent to complaint being opened, respondent went through all proper steps to obtain licensure for SDI Presence and is now fully licensed. A review of the license history for SDI Solutions shows their license expired July 31st, 2017, and that SDI Presence license was approved July 31st, 2017. So it appears there was not any unlicensed period. It appears the complainant read the slogan as part of the company name, leading to some of the confusion. So my original recommendation was to close, but considering there's a violation for not having a license number on the van, appreciate some discussion as to what penalty is normally applied to that situation.
Just a quick clarification, the van that did not have the license number, was that part of the van that was part of the company that was being bought, or the company that was doing the buying?
Company that was purchased. I'm not sure if there's a consideration that maybe they're given a window of time where they need to come into compliance or not. I guess I'm not really sure how this is usually penalized by you, being my first time.
If I can, excuse me, if I can address the board, typically in the failure to have a certification number on the van, we typically do a letter of warning, just by way of discussion.
Do we have a motion?
Yeah, I don't even know that. It couldn't hurt a thing. Let's go ahead and make a motion to issue a letter of warning to let them know that there should be a license number on the van.
I second.
We have a motion and a second then to issue a letter of warning. Is there any further discussion? All right, if none, if all in favor, if you'll signify by saying aye.
Aye.
That, I believe, passed unanimously. Thank you very much.
Entry number 4, there are 2 cases on entry number 4. First case is 2017-042851. Second case, 2017-042891. Summary is as follows. Complainant alleges Respondent 2 was attempting to sell alarm systems for Respondent 1 without obtaining proper registration. A review of the complaint shows the attempted sale occurred June 30th, 2017. Respondent 2 submitted paperwork to the board signed July 26th, 2017. According to respondents, the paperwork provided, Respondent 2 began employment on May 22nd, 2017. From the information provided, taking into account employees' right to work for 30 days prior to submitting an application, it appears that Respondent 2 worked approximately 34 days without proper registration. Recommendation against Respondent 1, which is the alarm system company, is authorization of a civil penalty in the amount of $100 to be settled by consent order or formal hearing. Recommendation against the individual employee is to close.
We're just talking about registered employees. We're not talking about QAs or anything of that nature at this point, right?
That's correct. It's just the duty to register an employee.
Respondent number 2 was an employee of respondent number 1, is that my understanding?
That's correct.
Respondent number 1, you are recommending a civil penalty based on not having submitted the employee application of respondent number 2 within the 30-day time frame.
That's correct. It's my understanding that general penalty for that is $100 per month. Employee is non-registered. From speaking with Ashley, and
Although they were in compliance in 34 days.
In 4 days.
It
He was
took him
just 4 days
6
late,
took him 64 days
wasn't he?
to come into compliance. So that's why as stated, there's a 34-day window where they should have been registered, but they were not.
The respondents in this, did they offer any explanation for why they had not submitted the registered employee in a reasonable time frame?
Not particularly. They didn't give a particularly detailed response as to why, but when I contacted them, they gave me all the information I requested as far as start dates. I think perhaps they just didn't know they were violating. It was kind of the feeling I got from their response.
I make a motion to concur with the recommendation of council on the amount of civil penalty of $100.
Second.
Okay, we have a motion then and a second. Any further discussion? All in favor, if you'll signify by saying aye.
Aye.
I believe that passes then unanimously. Thank you.
All right, and then I have the next case, Lindsay Shepard. I will actually still be staying with you as disciplinary counsel, so. it'll be similar.
Congratulations.
Thank you. It's a big honor. Case number 5 is 2017-025-101. This case arises out of a consumer taking pictures of a car displaying a sign with a licensee's company name. The sign included a telephone number. The sign did not display the licensee's license number. The licensee claimed they have no affiliation with the car photographed by complainant. The licensee also claimed it called the phone number displayed on the car sign, explained the law, and requested that the owner remove the sign. The owner agreed. The complaint against the licensee was closed. Upon the board's request, this complaint was opened to determine the owner of the car and the type of business in which he or she is engaged. The investigation revealed that the car belongs to the licensee's former employee. The phone number on the sign is the former employee's personal number. The licensee's QA claims that the former employee made the sign without the company's permission. The former employee then threatened the QA with a lawsuit. The QA then terminated the car owner's employment. My recommendation is to close.
Let me make sure I understand. If I understand correctly, there was an employee who had a company sign with their personal phone number on it.
And so this originally presented a case against the licensee at the last board meeting. So it was a similar name. So without destroying anonymity, an example is like Security Works Company versus like Security Workings. So it was similar but not quite exact.
Okay, so this was that an employee at the time or a former employee at the time, or do we know?
He was an employee at the time.
Employee at the time.
The sign was discovered, yes.
Okay.
So we think the sign is not in use any longer.
Right.
I think our concern, or my concern when this came before us, was if that person was still trying to engage in the alarm business aside from the licensed company. I don't think we wanted any action against the licensed company. We just wanted to know if that individual that was driving the car around, were they still trying to engage in the alarm business? So it sounds like they're not. So
Well, they were hired by a different alarm company, but they are a registered employee of a different company, and that sign is no longer in use.
Motion to concur with council's recommendation.
We have a motion to concur. Do we have a second?
Second.
We have a motion and a second. Any further discussion? If not, all in favor, if you'll signify by saying aye. Aye. I believe that motion passes unanimously then. Thank you.
We have a couple of represents. Case number 6 is, we have two cases there, 2014-024-291 and 2014-009181. This complaint was referred to the board by the Attorney General's office. The Metropolitan Nashville Police Department was contacted by an employee of the respondent who claimed to be a, quote, whistleblower. He said he was moved by the respondent to Nashville to learn a takeover technique whereby representatives make contact with customers with existing security contracts and tell them that they are to upgrade their system and, in actuality, change the system over to the respondent. The board investigators spent a great deal of time trying to locate the whistleblower employee, but they were unable to do so. The only violation that the investigation could definitely substantiate was that the respondent had conducted alarm sales activity before they had properly registered and licensed. Previous recommendation was to authorize formal and send a consent order with a civil penalty in the amount of $2,000 for engaging in the business of an alarm systems contractor without the proper certification in violation of 6232-304A. Updated information is that the respondent provided information showing the company had been licensed and provided documentary proof of the date of the employment of the individual and the date of licensure. New recommendation is to close.
Why did we originally think that they weren't licensed? Was there some confusion on name, or did we not know the name?
That's what the bottom part said is about the board open, and yes, there were two very, one, for instance, was an LLC, the other one was an INC. I did find the second complaint where we closed the first one, opened it up again. Part. Both companies are actually licensed.
So the recommendation now is to close,
Correct.
I would guess that part of the reluctance we have here is that the alleged activity by the so-called whistleblower would seem to be especially repugnant within the alarm industry, where someone is sent out to fraudulently take over a proposed competitor's alarm system. Again, I don't want to speak for the entire board, but that certainly is a feeling that I would hold. That is just a completely reprehensible behavior pattern. And even though it was not, we were not able to find evidence to substantiate that, that is certainly a business model that we see more of than we would really like. And in fact, our guidelines for the way in which companies are to operate their business address that in particular. But sounds like with the lack of evidence, unable to find the employee that came forward with that behavior pattern, and in light of the other situations, I guess that's where we stand at this point. Motion?
Make a motion to concur with council's recommendation.
Do we have a motion? Do we have a second?
Second.
A motion and second. Any further discussion?
I'd just say that I agree with you fully about the activity that was alleged, It's just that what we have here is about an unlicensed company, which obviously is not the case now. I mean, we know for sure that's not the case. I wish we did have more information about the other, but I don't see where we can move forward.
Further discussion? If not, are you ready to vote? All in favor signify by saying aye.
Aye.
I believe that motion then passes unanimously. Thank you.
Case number 7 is 2016-021671. Background, this case was presented at the June 26 board meeting. A complaint was administratively opened against respondent for failing to notify the board of the transfer or termination of its designated qualifying agent within 10 days. Respondent did not respond to the complaint. Previous decision was a $350 civil penalty for violation of TCA 62-32-304C, failure to notify the board within 10 days of termination of the DQA's employment, and Rule 0090-01-.0714, failure to respond in writing to the board's request within 20 days. New information is that respondent has been out of business for approximately a year, since at least September 16th, 2016. Respondent's license is now expired. My recommendation is to close and flag.
Board, do you have questions? Comments? Do we have a motion?
It's probably about all we could do in this situation. Yeah, I'd make a motion to concur with council's recommendation.
We have a motion. Do we have a second?
Second.
We have a motion and a second. All in favor, if you'll signify by saying aye.
Aye.
I believe that passes unanimously then. Thank you.
That concludes the legal report.
Thank you for your legal report.
Thank you.
I do have an addendum while we're on the legal report to a case that was presented earlier this year. It's case number 2016-060-001. I did give you all a paper copy of that. This anonymous complaint was presented to the board at an earlier meeting alleging unlicensed activity by respondent. Respondent company represented itself as a specialist in video surveillance. Respondent states that the equipment sold is used by a client for detecting and signaling an event. In the included letter, the respondent indicated that the customer would own both the cameras and access to the videos produced from respondent's equipment. The proposal included with the complaint does detail itemization for labor, which includes installation, wiring, and configuration. Respondent was found to be in violation of Tennessee Code annotated 62-32-304A for engaging in the business of an alarm systems contractor without first being certified. The board issued a civil penalty in accordance with Tennessee Code annotated 62-32-320B, being $1,000, and a 6-month period of ineligibility from applying for certification. For new information subsequent to this decision, respondent has been in negotiation with legal to settle the complaint. Respondent has requested that the board authorize a waiver of the 6-month period of ineligibility to allow the company to obtain certification and continue in its operation. And so my revised recommendation is to authorize the formal and send the consent order with the civil penalty in the amount of $1,000 for violation of Tennessee Code annotated 62-32-304A, and that the board will waive the 6-month ineligibility period to allow respondent to apply for certification.
Ashley, let me add to that just a bit, and I will have to recluse myself from any voting on this. We had an informal meeting with this company yesterday. They pointed out that they have currently a number of customers that are depending upon them for their service, and that is the reason for the request for the that we waive the 6-month ineligibility for to be able to continue in business. So with that, with any questions, or are you ready for a motion?
Well, our goal is always to get people into compliance, and we have waived this in the past. Where does the 6-month come from? Is that in the, is that a rule or in the law?
It's in the
Part of the
statute.
From the statute? It does seem like it's against the good of the public to not let them go ahead and get licensed at this point.
So it's not that they didn't have just a CCTV license, they didn't have an alarm contractor's license at all.
That's correct.
But they also weren't doing anything other than CCTV.
As far as
We
I
know.
can tell from the complaint file.
I'd make a motion to agree with the recommendations from council to waive the 6-month waiting period.
We have a motion, do we have a second?
A second.
All right, we have a motion and a second. Any further discussion? If not, I assume you're ready to vote. All in favor, if you'll signify by saying aye.
Aye.
I believe that passes unanimously then. Thank you. All right, does that deal with all of our legal actions?
Yes, sir, I'd like to, if it's all possible, take about a 5-minute break.
Take a brief break. All right, why don't we make that a 10-minute break? We will come back at, make it quarter. All right, the board will come to order. If we are now ready on our agenda to deal with appearances. Cody, would you like to be in charge of that, please, ma'am?
Yes, sir, thank you very much. If you turn to your iPads, we're going
Mr. Marcus Roy.
A or B?
to A. Isn't it A? Mr. Roy, they have not seen it. So if you would give the board members, please, a few minutes to be able to read over the material.
Mr. Roy, if you would, well, it looks like you're signing in. I wanted to make sure that you were doing that. Good.
Mr. Roy is here for you to review his application, employee registration application. Our protection. Apparently there was a misunderstanding and his qualifying agent did not come with him this morning. But, all right, we'll go ahead and talk to Mr. Roy since he's here.
I think we're still going through the documents that have been presented here.
Let me help you a little bit because it was somewhat quite confusing to me as well. What we have is a March of '87 assault, which was probation violation, and also in '87 he was guilty of burglary, forgery was dismissed, bad check was dismissed, concealed weapon was found guilty. '87, now this is just off the information that I received. Mr. Roy, of course, will explain it. In April of '87, it was the larceny, guilty, burglary, and there was nully. There was also some probation violation. '89 was forgery. It said 10 checks, received 3 years. Also in '89, it was breaking and entering that was dismissed. Then at the November of '89, it was theft, which was 2 years. But he was sentenced. 95 is burglary, violation of probation, 3 years for daytime housebreaking. Of course, these are all old, and that's the reason we're discussing them. 1999 was theft under $300. That was 3 years. In 2000, burglary in the first degree says 3 years. So I do believe some of this is probably have been combined together. And in '05, it was trespassing and harassment and burglary, got probation for a year. Now, you will see other charges on there, but you need to ignore those or other. No.
All right, Board, have you had an opportunity to review the documents? All right, Mr. Roy, since we have a rather extensive record here, let's give you an opportunity to make a statement, and then perhaps the board members would have some questions for you. Would you like to make a comment?
Well, I made some mistakes in the past. Haven't made them 2005, and I've been doing fire alarm since, well, basically I've been doing special hazards since 2000. Homeowner. My wife's family law attorney. Got a son in the Navy, one grad.
This license allows you to also install burglar alarms. There's a lot of the concern with some of the older charges. And even the 2005, I mean, I guess it's still pretty old, but it doesn't, if we were just looking at the 87, 89 stuff, that's a long time ago. But we do have, I've got concerns, I guess, that it's, you know, it's still continued on past that. I guess, what's different today than what happened in some of those other years?
There's a point in my life where I just, I guess I can say I really didn't. I had children at that time, and I think that's what kind of woke me up. I didn't want my kids to take the same road I took. I had to change, and that's what I did. This worked out. Tough city, you know. I'm not using that as an excuse. I was having fun, but apparently I wasn't. So, but past 12 years, my record speaks for itself. Whatever happens today is God's will, so I'm good with it.
How long have you been doing these fire alarms and the, I guess y'all do some of it in Georgia as well or something, or?
Well, we pretty much work all over. Our company has several offices in several states, including Texas. I work with special hazards. I put in clean agent systems. Y'all may be familiar. Fire alarm is something I've started doing, I guess, about 5-6 years ago, just to qualifications to my resume. I'm a project superintendent now, so I don't do as much hand. Qualified, but they don't have the license. So you have to have special license. Probably best at it. I ain't talking about just in the state of Georgia. Really good at what I do. Really good at what I do. So, and it's
basically, you've been doing fire suppression then up until recently, and now, of course, Century does fire protection as well as moving into the alarm systems and installing the fire alarm systems. And so, if I would understand correctly, that you want to be able to expand your ability to work with the alarm systems as well as the suppression systems you've been doing thus far. Is that a correct understanding?
yes, sir.
Okay.
I have, it's interesting because I do a lot of work for a lot of secured places like Delta and places like that. And I know my past is going to always be one of those things that when I'm trying to, when the company is trying to get me into a place like this, that I'll have to have.
We don't have the opportunity to go back and change our past. All right, Board, do you have further questions? Where do you feel like we should go with this then?
Make a motion for approval for employee registration.
Second.
All right, we have a motion and a second. Is there any further discussion? Are you ready to vote? All in favor signify by saying aye. Aye. I believe that passes unanimously then. Thank you very much, Mr. Roy. Best of luck to you, and
Thank you,
I hope that you'll continue on the path that you present to us at this point.
Absolutely.
Great, thank you. Congratulations.
All right.
Mr. Roy, you'll be hearing from us later. All right, I think the next on my appearance is Mr. Nichols. Mr. Nichols, would you come in? Case is somewhat different. You do have, I believe, this from the FBI. Mr. Nichols' company and himself as the qualifying agent have renewed. You will see in your packet that there are registered employees. Some of them have been renewed and some of them have not. And that's why he's here today. The registered employees expired in March. They only have 3 months, which is April, May, and June, to renew. And he is actually asking us, under those circumstances, which he's going to explain, to go back and reopen up those registered employees. By statute, you're the only ones that's going to be able to let me override the 3 months of late fee and give me permission to go back and open up the applications. So if you would, Mr. Nichols, you need to explain the circumstances.
Good morning. Where to start? When we received our renewal paperwork in the mail for our registered employees earlier in the year, it's my understanding that everything was filled out completely and sent in. Shortly thereafter, we were receiving a lot of letters from the board, or the Alarm Contractors Board, requiring additional thises and that's. It was passed along to a bookkeeper, human resources person that took care of all of my licensing, renewals, and so forth. My understanding was that everything had been submitted, taken care of. Shortly thereafter, I was made of some situations. The situation was this employee that had worked for me for 2.5 years had been embezzling money from the company. Prior to May the 2nd, my understanding was not only had all the paperwork been submitted, but any requests from the Alarm Contractors Board that may have been needed, additional pictures, whatever, had all been sent in. About a week after me letting this person go on May the 2nd, I had 2 people show up at my home, and anyway, to my surprise, it was 2 FBI agents. They came to my house, wanted to speak to me privately about the employee that I let go. They, at that time, did not know I had let her go. They thought she was still in my employment. They had been investigating her for about 9 months, and they were coming to me asking for help. They wanted to do an undercover thing while she was still working for me. But during our 3-hour conversation, I let them know that I'd already let her go, that I'd found out that she was embezzling from me. Well, they had known about it for about 9 months. There's also other things and other people that she was conning and embezzling from, and extortion and all kinds of other things. She's destroyed someone else's life. But of course, the FBI can't give me all these details. They just said, look, she's a bad person, she's a manipulator, she's doing all these bad things. You've already let her go, we understand. Would you help us? Most definitely. So from that point forward, the FBI was in my office 3 days a week. They were going through computer files, her computer and our server. Come to find out, she was impersonating a federal agent. They found all kinds of paperwork on her computer where she had manipulated documents showing that she worked for the FBI as a forensic accountant and other things. My understanding is she was using this information to somehow or another blackmail people into getting money. She was using my company funds, gas cards to during her 2.5 years, she had had cancer twice. Her son had had a heart surgery. All these things had taken place. Well, no, it was just an opportunity for her to leave the company in little time bits to go and do her extortion around the southeast part of the country. From what I understand, some of it was taking place in Georgia and other places, and she was traveling during these times where she was getting chemotherapy and things. So anyway, a lot of time I devoted to assist the FBI in record keeping, when she was in our office working, when she wasn't, computers, reports on different things, phone records, you name it. So there was all this extensive stuff going on, as well as meeting with the bank to document the $313,000 she had stolen from the company over the past 2.5 years. So needless to say, my time was very short. I didn't have much time with all this going on. Several weeks ago, I found out that several of my employees, their registered licenses never came back. They were expired. I didn't understand. I thought everything had been taken care of. They'd all come back. So I reached out to Beth Bell, trying to say, Beth, what's going on? Why aren't these? I got the email back. She was on medical leave. Finally got through, and come to find out, I guess a number of my employees, due to some things that maybe were asked, never got sent back like I thought they did. So, at that point in time, my only point was, what do I need to do to get these registered employees registered properly? Yes, it would be nice if some fees were waived. I'm not even arguing that point. I'll pay the fees. I just need to make sure that everything is done correctly, that all my employees are registered properly. And, I was asked to come here today. So I'm here. The special agent in charge, from what I understand, has written a letter and maybe made a phone call. Again, whatever the board can do, that's great. I'm not asking for, again, like I said, I'm not even asking to waive the fees. If they do get waived, that's great. But I just need to, I need some direction on what I can do to make everybody to be in compliance.
And as Cody said, the registered employees, those licenses are currently expired, and so we would need the board's authority to go back and allow him to renew those rather than have those people reapply.
Our records show that there's 21 employees and 12 of them are expired. So what that means is he'd have to pay the renewal fee of $75. The late fee is $22.50. Late fee. I will reopen the file. You still have to pay the $75 for the renewal.
When was the company license renewed? This would have been the first renewal with the new employee renewal.
Yeah, it would.
Paper. This is on a paper. It wasn't on the online thing.
Well, I was referring to, though, the fact of where the employees are renewed separately instead of where
Yeah.
it used to be, we'd just
No.
renew them with the main company license.
Yeah, we used to be able to, yes, they would send it a roster of their employees in.
But he's saying
And
this
that's-
happened after that
yeah.
change.
There was 20-some employees, and she, whoever she is, only renewed 9 of them.
No, we didn't see any sense in that either, but that's where it happened.
Some things don't make sense. Yep. All right, so basically the issue here, let me make sure I understand. I'm slow to understand sometimes. A variety of circumstances that you've outlined, and of course we do have a letter from the FBI here, which certainly in my mind carries some weight. Basically, the issue is he has 12 employees whose registrations have expired. And if we are in a position to waive the renewal, then he could go, or to waive the circumstances, he could renew these, and you still have to pay the fee to renew them. But they wouldn't have to go back through a complete re-registration process with fingerprints and photographs and all this stuff. And the late fees involved, where you indicated were $7.50.
It's for, yes, for 1 month of that.
For the 3 months, and that would be times the 12 expired employees. Okay.
Well, I think that's where we're at. We're looking at 12 employees at $75 each, if you agree to override for me to override the late fees. And those employees would be registered, they would not have to
Reapplication process becomes involved, and there are a number of fees involved, and fingerprints and photographs. And
The fee would be $100 then, and then they're going to have to spend the time to have the prints taken, do the photos, and be processed, yes.
I just wanted to make sure I understood what we're dealing with here. Board, do you have any questions? Have some action you'd like to see taken?
I would make a motion that we allow the renewal of the 12 employees without reapplication and without late fees due to the circumstances.
Okay, we have a motion.
A second.
We have a motion and a second. Is there any further discussion?
Aye.
I was ready to vote. Vote before we even call for it. All right, all in favor, you'll signify by saying aye.
Aye.
I believe that passes unanimously then. Thank you very much. Mr. Nichols, I'm sorry you had so much difficulty. I'm sure you're not thrilled with that prospect having happened either, but maybe this will let you move forward in a reasonable fashion. Thank you for your appearance today.
Mr. Nichols, it'll take us a lot of work all this up, so we'll be calling you and getting it all straightened out with you.
Okay, thank you.
Is that one of the lady that got fired, was that one of the registered employees? Should we? That wasn't one of the 12, was it?
I'm not in position to say. Okay. Because I don't know. Okay, we do have one more appearance. You do have the handout. It's not on your iPad. This, you've already heard the, well, Mr. Campbell, if you'd come in and sign in, please, with your qualifying agent, with your company owner as well.
Just gonna leave it down. Stood up good for a while.
It's stuff written on it. Mr. Campbell is here for you to review his application to be a qualifying agent. I believe that application is in CCTV.
Whose application?
Now, did I say? It is a new application. To talk to you about his experience. It is somewhat outside the line of what the statute says. So we did ask him to come today to explain his education and his qualifications. So if you just give them a few minutes, Mr. Campbell, to look at the information that they have before we start talking. Okay, Mr. Campbell, did you want to review some of this, this letter that you sent to us on May the 3rd with the board? I'm sure they...
Yes.
So, thank you for the opportunity to come here this morning and petition for an appeal. One of the things that we have realized is just the dynamic change in technology that we're involved in and how we kind of backed into this being under the jurisdiction of the Alarm Board. Our company is only interested in cameras and camera technology. We're not interested in connecting with any alarm signals that would be require resources from an emergency response. Okay, if I may, I'd like to just read some of the letter from May 3rd. So, please consider this an appeal for an exception to be made in acceptance of my experience as qualifications met to be the QA for ION Technologies Corporation. During my time at Auburn University getting my Bachelor of Industrial Design in '96 with a business minor, I developed a mantra: be a champion for the consumer at the beginning of the product development process or design process. With over 21 years of professional practice with guiding principles have proven its value, resulting in millions of sales as well as subsequent satisfied consumers, as well as over 38 patents. Since 2011, I have been engaged with Britt Summers as a business partner in developing IT-related consumer-driven solutions. My substantial experience in corporate user needs research and technical product development knowledge has been uniquely valuable in our business partnership. I strive for excellence, which enables me to deliver above expectations usually. Over our 13-year friendship, there's no friend that has had my trust more than Britt Summers. And I get into this, the concept of trust. And this is kind of a family kind of group. We've had several of our relatives work with us. So we're very closed on some of these ideas, very trust-oriented, which translates into consumer advocacy and consumer values, which, as I understand, that's the primary function of the legislation and the board is consumer advocacy. And we're very much engaged in that. We have lots of recommendations from everything we do is by word of mouth. That's the way we develop our business. We have a lot of people who really appreciate what we bring to the market with respect to trust. So I have been involved to some degree in every aspect of ION since 2011, including our brand identity and values, defining our values and bringing those to market. For sales, I've built compelling tools to creatively engage potential clients in an understanding not only what they say they need to see, but also allow them to understand the potential to get insights in ways that they never imagined, given the current state of technology and the tools available. I've closely worked to build business partnerships in the U.S., Asia, and European technology partners that have resulted in innovations awards recognized by a German manufacturer with the intent to understand how to solve or avoid consumer problems. Given a strong mechanical aptitude and focus on the importance of the consumer experience, I'm keenly aware of execution details, and I'm competent to use a glow rod to terminate Cat 6 and know the difference between plenum and exterior cable and when they're appropriate. There's lots of good business practices, best of breed kind of approaches to problem solving from a mechanical side that we've gained over this experience. Managing resources to meet quality expectations and ensuring customer satisfaction have been my primary responsibilities. Our initial ION business interest formed around realizing the dynamic changes in the technologies that enable solving problems in novel ways. We developed solutions ranging from remote viewing of time-lapse images for construction progress documentation to customized mechanical solutions specially designed for pharmaceutical clean room compounding boxes, as well as using video analytics devices to capture demographic data to gain insight into consumer behaviors, marketing, and product placement planning. ION has not taken anything like a traditional route into the Alarm System Contractors Board jurisdiction. So we find ourselves here today. particularly since we had no business interest in sending signals to trigger a response from emergency personnel. So we have been keenly focused on understanding consumer needs, overcoming the learning curve of technology changes, and understanding market dynamics that we have only recently understood how we fit under the jurisdiction of the Alarm System Contractors Board. That said, we also understand that ignorance of the law is without excuse and are eager to comply. To date, we have submitted all of the known requirements for licensing and have paid dues. We have, so the only question, or the big questions remaining, to our knowledge, is acceptance of my academic credentials with a 4-year degree from Auburn University and a technical degree in industrial design, and the experience that I have. So these are the two primary considerations for the QA we're asking for. Then there's the exam, of course, that needs to be passed as well. And if I do not meet this, if I do not meet muster with respect to the academic credentials and experience, then we need to find a QA that is qualified and just hire them outright. So, you know, the question is a petition for acceptance of my academic credentials and experience. Ultimately, we want to be able to offer competitive solutions utilizing video-enabled devices to address a broad range of consumer needs, and that includes what is covered under the current legislation of the CCTV category. It is our intent to operate in compliance with the law and be in good standing with the Alarm System Contractors Board of Tennessee. I appreciate the opportunity to have my experience considered as an exception to meet the qualifications for assignment as a QA for Iron Technologies. So, list of it.
Campbell, I appreciate that. Board, what, do you have some questions? What are your thoughts?
My concern's all the unlicensed activity in the past. Basically, your letter just told me that you've been doing this since 2011, and it's all unlicensed activity. It doesn't matter if it's calling, summoning help. Everything you described requires a license.
And to that point, I will say that there was, so the company came to our knowledge through an unlicensed activity complaint, which has been presented and settled before the board.
You guys know technology has changed. We had no clue about the
I would think one thing you reference is saying that technology's changed. I think you would be hard-pressed to find any qualifying agent installing the stuff that you list as old technology. Yes, it's changed, but the new technology you're talking about is standard in the industry, and it definitely is a violation of the law.
Well, we're not disputing that.
Okay.
That's why we're here.
But it sounds like the letter's trying to sell us on that more so than address the issue of the QA application.
Yeah.
I wanted to make sure we'd address the unlicensed activity, so that's already been addressed in a different.
Scott, that has been addressed
Okay.
and appropriately dealt with, I believe. So,
We don't know. When we see some of these, we don't know who the actions are against, so.
but that has been reasonably dealt with.
Okay.
So really the question we're dealing with at this point is Mr. Campbell's qualifications and his application as a QA.
Specifically, the education and experience, because they don't squarely fit within the statutory requirements, and of course the board is the only one with the authority to deviate from that.
Let me ask, and of course this was really the first time I've seen the credentials presented. What exactly do you do, and what exactly has been in your experience in the installation and for the closed circuit television? I say closed circuit television, the television industry.
Video surveillance.
Yeah, video surveillance, but probably a better way to.
Yeah, it's video surveillance, which is what we were we're our only interest. So we're not interested in, burglar and fire alarms. It's just cameras and camera work. So my experience has been a broad range, everything from climbing ladders and installing wiring, doing all the details for a quality installation, giving best practices, and working with other contractors, subcontractors to, learn how they install. So on the installation side, to the IP configuration, setting up all the network stuff and understanding computer, as well as working with manufacturers to understand how to use the technology and the tools. Mapping and lots of different things. So it's a broad spectrum, everything from sales to installation, or from working with manufacturers to the end user.
If I may say something, we, like most traditional companies in this space, have no trucks and ladders. In fact, we obviously have installation services, but we rely on subcontractors. Furthermore, a lot of what we do is integration work, all of these being IP-enabled devices. Maybe that's further context on the kind of experience you could expect from this.
Are the contractors that you're using licensed?
They meet local, permits are pulled, Bixie certified.
That wasn't my question. Are they licensed by the Alarm Contractors Board? It's required that they would be.
Okay. In some cases, yes. In some cases, probably.
For your information, if you do get licensed, your subcontractors have to be licensed as well, or you and that person are in violation.
It's my understanding, Mr. Campbell, that you have not yet taken the examination for a qualified agent.
That's correct.
That's correct. Okay. So basically, in order to be issued a license as qualified agent, we would have to accept your academic credentials, your experience, and then it would still be dependent upon taking the appropriate examination.
That's correct.
Yeah.
And to comply as well.
Like I say, at this point, we're looking at the basically the question they have before us at this point is your qualifications.
Yes, sir.
And I understand that's what we're looking at. What concerns me is you keep going back to trying to say that you're not doing alarms and you're not doing monitoring, but CCTV, which is video surveillance, it's irrelevant. What you're doing, aside from those things, is a violation of the law. It's like you keep going.
That's why we're here. It's to comply.
Right. But
It's
you keep
confusing to
Well, forgive us.
someone.
This is a pressing moment.
It just
Okay.
concerns me that you keep trying to say things. It sounds to me like you're trying to say, well, we don't think we're in violating the law, but we're getting licensed anyway, because you're saying things that like those wouldn't matter. But everything you're doing requires a license, aside from all these things you're saying you're not.
Sir, I'd submit that we are here because we acknowledge our need to be under the jurisdiction of this board.
If you take the CCTV and you pass, you still have an alarm license classified in not only burglar alarms, but CCTV also, which means you could go back and do burglar alarms with no experience.
We have no burglar alarm.
We have no.
You have no interest in it
at all.
today. I understand.
They'd have to get a separate QA for burger, or add that.
Yeah.
Well, they have to have an alarm license, period, and
Right.
then have the CCTV classification.
Right.
Well, we just want to specialize in cameras. If secure surveillance. What we're more interested in than anything, we don't want to send alarm signals. So how do we get qualified for that? All we're interested in is hanging cameras and configuring them and addressing user needs.
And
We're
being
not
compliant
interested
with
in
the law,
and
of
that's it.
course.
I believe the basic question we're dealing with is the credentials that Mr. Campbell would bring. Board's willingness to accept. He has a BS in industrial design.
Yes, sir.
And so you presented a copy of your diploma from that, so that's pretty clearly set. And whether or not we would require or allow the industrial design degree to reasonably meet the statutory requirements and the experience. Basically, what you're saying is from 2011, since 2011, you've worked with ION, is that correct? Or
Yes, sir.
Have you worked with any other companies in the past that have any sort of closed circuit television, alarm-related experience?
Another company called Community Security that was, and I did.
When was that, Mr. Campbell?
Is in
Approximately.
2011, 2010, 2011.
That was basically a sales position.
Sales and marketing, yep. Yeah, I mean, yeah.
Their go-to-market was alliance-driven through nonprofit entities in the Memphis. Trying to influence.
Basically,
He's not going door-to-door selling contracts. Okay. Or to commercial entities. I just think that's important to clarify because he would not have been required to have been registered.
Basically was a sales marketing position with that company at that time. Okay. What's the board's, what do you think, board?
What's your feeling on the main thing is the degree?
The degree and the experience.
I would accept the experience. It sounds like he's pretty well testified here that he's been doing this since 2011. I would, not to, I think we get off track, but we could delve into that sales job because it sounds again like you're saying it wouldn't need to be licensed, but anyone selling any kind of video surveillance, to whether it's to a nonprofit or it has to be licensed.
No, it wasn't video surveillance.
Well, but anyway, we're getting off track there. So.
It was alarm systems.
And it would have had to have been
I was
licensed.
just helping with a marketing and sales position with alarm systems.
So were you registered with the alarm board?
I was not.
Yeah, and that would have been the company that fault there, not you, but you should have been registered with in that position.
I'm beginning to realize that.
I think it's become clear that these folks have come forward.
They wanted to comply.
Basically, a little bit of the history. Basically, there was a complaint. At that point, they realized they needed to be licensed. The complaint has been settled, and now they're trying to move forward in a status that would be compliant with our board and the statutes. So that's kind of where we go. Now, the question is whether or not we are willing to accept Mr. Campbell's academic credentials and experience as meeting the statutory requirements. If we accept that, then he can take the exam and then move forward as their qualifying agent. If we do not accept that, then they've got to make some arrangements quickly to obtain a qualifying agent so they can continue their business model.
Thank you, Mr. Roberts.
Thoughts, suggestions?
I tend to agree with everything you're saying to this point. I think obviously the experience is there. I think there has been a lot of activity going on that should have been recognized before now, but I think we've done a good job of pointing that out. Just curious, have you seen the little book that says alarm licensing law on the front of it? Have you read that thing yet?
It may not be printed.
There is no book. He did not get you got the red book. He didn't get the red book. But he has been out on the internet. He's been out on the internet and saw and
We've gone
filled the
to
applications out
paperless,
online.
high-tech society.
Right.
And quite honestly, I think Mr. Campbell is a part of that society.
Well, I was being facetious. Well, it used to be a little red book.
It is
We
no
have it
longer
all, but-
available.
It was a listing, it was a printed edition of the statutes that we operate under.
You can now find it online.
The only thing I want to interject here is perhaps if Mr. Campbell did not pass the CCTV exam, I think they did make a statement that they would go out and get a qualifying agent in that classification to give Mr. Campbell time. If not, Mr. Campbell would need to take the exam again, and then need to have your permission to go ahead and give him an extension through our office if that's necessary. So I don't have to bring it back again. But
The
we
company
will-
is currently licensed or waiting on a QA to be licensed?
They're waiting on the qualifying agent, yes, sir, to be licensed.
So basically, the entire operation is depending on his having a qualifying agent. Okay, you ready to make a decision on this? Do we have a motion? You want to delve into this a bit further? I'll flip a coin to see who makes a motion.
I'll make a motion to accept the degree.
Mr. Campbell's academic credentials, as well as his experience, is meeting the requirements for a qualifying agent.
And then we also need to add the ability for an extension if necessary for the company.
A 90-day extension. All right? We have a second?
Second.
We have a motion and a second. I hope you got all that down over there. Good. Then, all in favor of the motion, if you signify by saying aye.
Aye.
Any opposed? Motion then passes.
Thank
All
you.
right, very good.
Thank you.
Mr. Campbell, congratulations. Best of luck when preparing for the exam and taking that, and if you overcome that hurdle, then you're good to go.
Thank you, sir.
Thank you for your time and effort.
Thank you.
Okay. Thank you.
Thank you, Board.
Okay.
Thank you.
You're welcome.
All right, Cody, are we ready to move forward?
Yes, sir, I believe we're on administrative matters now, which usually moves pretty quickly because you've already been given that information. We'll go ahead and take the monthly report. We just have June and July. Again, for the record, I will say that we do have 2 board members that had expired. That is Karen Jones and on both the monthly reports. If there's no questions on that, we'll just move right ahead on that. Like I said, you've been given this information ahead of time. We'll look at the budget review now, if you got that on your iPad. Rather quickly, if you can, as you can see, it is the end of the year budget. We ended up with a total of $2,056,269. The alarm board did. We are still and will still be paying in this from what I understand, in this quarter, some more for our computer database as well. You will see that's under Edison expenditures. Some months was a good bit, some months it were not. But we did end in the black like we usually do, so there is no fear of being for a sunset. But if we do get called to the hill, I will ask the board to appear also with us.
That's to share in the blame, is it not?
No, that's the share in the, hey, you're doing a good job. The Hill does like to know that the board appreciates that, and they do like to meet you, see that you was much as we do. All right, see, the next one, there's legislative update. We don't have any legislation update, there. Application reviews, we did one this morning. Mr. Roy. So. We have no request for an extension. We'll just move right on down to the criminal history. And that should be on your iPads as well.
At Exhibit A,
I thought it was C.
History Review Exhibit A.
got A, B, C, and D, it would appear.
All right. You got,
Would it be appropriate to note that our staff doesn't have to deal with the iPads, but has real paper to wave in our?
no, sir. See, I do have an iPad, and I do use my iPad. It's just I make some, it's hard. When they give me an apparatus to use that I can make notes on and go back to my office, I won't be using the paper.
I understand.
All right, so I think we're on A, which is, yes,
Mr. Aaron Bobick.
Bobick. What we have here is a DUI from 2002. We have a 2002 grand theft, convicted, 3 years of probation. 2004 burglary, 1 count was dismissed. Petty theft, you have petty theft, 1 count, 2 count, 3 counts. He got 3 years probation, had to pay restitution, and then again he was found guilty of a DUI in 2004. No, sir.
In his letter, he references that it wasn't on the original application. Is that why it's before us? Would you have approved this, or is it because of the charges?
It's before you because of the charges.
He said he didn't realize he had to report charges over 10 years ago, but our application says,
Right.
have you ever?
I just thought they were on the application that I'm looking at, but was it not on the
It's on
original?
ours, yeah.
That's what I mean. It was on this application, but he sounds like he had another one that it must not have been on.
Right here, have you ever?
Yes, it's material misstatement.
Next page has it listed. Charges are listed on page 3 in this application, but his letter says that he didn't list them.
On his first one.
First applica, yeah, this is a reapply. This is his second application.
The first one was denied for material mistakes.
I couldn't help
First one, what we had to do.
but note with some interest, he was charged and apparently convicted of grand theft, and he got 10 days in jail. A year later, a little over a year later, he was convicted of petty theft and got 20 days in jail. Seems inconsistent to me.
Second offense.
I personally have a great deal of reluctance to approve an application where there's been theft or burglary involved.
I agree.
I'd make a motion to deny at this point, and if he would like to appear and speak with us,
I'll make a note of that.
Okay, so we have a motion to deny, and of course, he would have the opportunity to appeal that, and Cody indicated that she would indicate that in a reply to him. Do we have a second to the motion for denial?
Second.
We have a motion and a second. Any further discussion? All in favor, if you'll signify by saying aye.
Aye.
I believe that passes unanimously then. Thank you very much.
All right, we'll go to the next one, which is Exhibit B, Briscoe. This is a relatively a new charge. He did have a 2005 a domestic assault that reduced to battery, and it was dropped, but then we have a new December 2016 domestic assault. Record shows he's guilty.
I was doing a pretty
Third row
good,
down.
I was doing a pretty good job myself.
This is an agreed order of retirement.
Okay, I think what I'm going to need to do with this one here is to recall this back. If you would see the agreed order of retirement, it does have a date of May the 12th of this year. I have no more correspondence, so I don't know if it has been retired or not. So I feel like I do need to go back to this gentleman and say you need to provide me with more court documents, if that's okay with the board. Or you can make your decision based on that.
What's the board's pleasure?
Helps, but it's not looking good at this point.
What are you saying, Cody, that some of this information should not have been presented to us or something, or it shouldn't?
It's not that it shouldn't have been presented with the agreed order of retirement. If the applicant did go back to court and ask for this to be dismissed after he met all of those conditions, this may not have presented it, but she would have also stated that it was dismissed. And so I think she's asking for the opportunity to go back to the applicant and request to see if he asked for this to be dismissed or if this is still a current guilty charge.
Do we need to make a motion, or are you just going to pull it, or what are we doing?
I don't think we need a motion. I can just pull it back out and just tell you that Exhibit B is going to be removed from the agenda.
I think it'd be perfectly in order if that's what you feel like would be appropriate. All right, then let's move on to the next one.
That's going to be Exhibit C.
Lisa Call, is that correct? Okay.
Yes, sir, it is. It's
Guard application.
application. This was the test and you passed.
We're awake.
Yes.
Does that mean we can be QAs?
No, there might be a little bit more.
All right, so we're moving on to
We're moving to
Exhibit
Exhibit
D.
D. Yeah.
Dwayne Lyles.
Yes, sir. What I have there, usually what transpires in the Navy, or in the military, we do the DD 214, whatever. Can't keep this on. They restricted his leave and they charged him with some loss of pay. But we do have the 1999, possession of marijuana, terrorist threats, and banishing a firearm, which he got probation, but his probation was revoked. But it has been a long time ago, but I felt like it still needed to come back because at year 2000, he was found guilty of burglary and vehicle theft, got 16 months in prison.
We've got a 95, it would appear.
That was the military one, is it not?
Yeah, it says he was charged with theft. Okay, and then possessions. $1,000. It would appear. Stolen property. Several charges there. That was in 2000.
Yes, sir, that's the one that you'll see further down. It said, received the stolen properties, it was 16 months. He does have a letter there.
I understand from the application that Mr. Lyles is a resident of Alabama.
Yes, yes, that's what he says on his application.
Montgomery, Alabama.
Yes, sir, that's where the company's located as well. No, it's
He's been in the industry because he has a level 1 class in '09.
Is this a monitoring company that he would be working for, or is this an installation company, or do we know?
I did not look that up, no, sir, I didn't.
Okay.
It's called Capital Business Equipment. Company's listed as a Bergen CCTV company.
I would guess from that then they are, would be planning on using him as an installing technician of some sort, probably working up into the Tennessee area. Yep. All right, what's the board's pleasure in this issue?
It does say field service tech, and it says he's been employed since 2005 with
Alabama.
Right. I'm not saying it was unlicensed or anything.
Don't have any letter of recommendation from the QA, anything like that?
All you have is his explanation.
Think
I don't feel like I really entirely understand what happened or what was done. It doesn't really say what the theft was. Basically, all happened at one time, right? All of those charges are one.
In
95, there was some sort of problem while he was,
Military.
presumably while he was in the Navy. Basically, focus more on the 2000 arrest, and it's certainly not clear what was taking place there.
The theft, I guess, is the most troubling for me, but it's not real clear what this was.
Well, you know, we
Let's see,
can
looks
always
like-
ask him to come in if you want to at the next board meeting.
Looks like there are 3 charges here, if I understand correctly.
Yes.
Riverside, California. There was the charge of burglary, receiving stolen property, and vehicle theft. So there are 3 charges there. And he has not disclaimed those in his letter. Feel like that you want him to appear before the board?
That would make me feel better. I'll make a motion to deny with, we don't have to add anything else to that, do we? They basically have the option to appeal.
If that's what you want, I'll ask him to appear. But if you go and vote to deny,
Let's,
you reapply and appear,
Yeah,
or
if
he's
we-
just going to appear and discuss this one.
if you want him to appear, let's invite him to appear before the board. And if he chooses not to do so, then perhaps we could go ahead and deny the application. Does that sound like a reasonable approach? Give him some reasonable period of time to appear before the board, perhaps at the next board meeting. And if he does not do so, then his application would be denied. Does that sound like reasonable? Would that like to be the motion that you would see?
Yes.
All right, then he would be invited to attend the next board meeting to appear before the board, and if he chooses not to do so, then we would deny his application. All right, that would be a motion. Do we have a second?
Second.
We have a motion and a second. Any further discussion? All right, are you ready to vote? All in favor signify by saying aye.
Aye.
I believe that would be unanimous, and the motion then passes.
Did we do something different earlier on one of them? We denied someone, I mean, I'm never intending for them to have to reapply or pay fees if they want to come to appear.
So you denied the very first.
So that they would have to pay fees or reapply.
Unless you want that one to come before the board too, let me see what the individual, it's a Utah company.
I was just asking. I'll try to remember that in the future.
Well, do you want to revisit that?
I don't think I made that motion, did I? I seconded the motion, I believe.
Well, it was a unanimous vote in favor, so if anybody wanted to revisit that, we could certainly do so. Is that correct?
Okay, what I've done, I have denied the application. He does have a right to appeal that, if he wishes to do so. I'll send him a letter, and it has the appeal process in it, and then he can come back before the board if needed be.
All right, very good. All right, are we ready to move on? Cody?
Yes, sir, I believe we're on the, last thing that I have actually on the agenda is the course approvals or review. I believe we sent some out to Mr. Roberts and Mr. Harvey and Mr. Cockcroft there. I believe, Ken, you probably got the first 4 that are Electronic Security Association, the National Training School. They have an hour for each one of those classes.
I got some of the ESA classes, as well as the,
Oh, I think what you've got with the new instructors for the HIC Vision.
right,
Their classes have already been approved, but they want to have these instructors approved, is what you had, I believe.
I think I had both, actually, but they both looked fine to me. The instructors for the existing courses.
Do you recall what those courses were? Let's read that into the record if you have that information readily available.
Let me see if I can find it.
This is from Alan Swartz as a Learning and Development Management at Hikvision USA. We wish to submit the resumes for 3 individual instructors to be authorized to teach their classes, is what it's for. Tim Sawyer, David Turner, and Jonathan Lim. Lim, that's how I pronounce that. It's not for their courses, it's for the instructors.
Them as instructors?
Yes, sir.
Were you comfortable with that?
Yes.
Okay. Then what was next? I have 4 courses that were submitted for my review.
Yes, so you had the Electronic Security Association, the
Okay,
National Training
I had
School.
4 courses. Let me read those. One was the National Electric Code as it applies to fire alarm systems for 1 hour of continuing education. The second one was General Session, Innovate or Else, for 1 hour of continuing education. The third course was Public Safety Luncheon, Video Surveillance, focusing on the evidence, 1 hour of continuing education. And the fourth course was Opening Keynote, Lessons in Leadership, for 1 hour of continuing education, and I would recommend that we approve all 4 of those as requested. Were there other courses as well?
There's some Nortec on here. I didn't get those. I guess Keith got those.
Okay, you had the Nortec Security and Control Linear Pro Control Certified Technician for the 6 hours of continuing education? Then you had the 2 gig Vario Certified Technician. They requested 4 hours of continuing education. Then it was again 4 hours of education for the GC2 Certified Technician. We also had the E3 Series Certified Technician for 6 hours. The 2 gig GC3 Certified Technician for 4 hours. And I believe the last one was the 2 gig GC2 and GC3 Certified Technician. All of these with Nortec for 6 hours.
All of those for continuing ed.
Yes, sir, that's what they asked for, was all continuing ed.
Okay, good. Then that would be your recommendation. Were there other courses?
That covered them.
Okay, we have 3 sets of recommendations. Is the board willing to accept those? Let's put that in the form of a motion. We would have a motion then that the recommendations made by individual reviewers of the courses that were listed would be accepted for the continuing education as they've requested.
I'll make that motion.
Oh, we got a motion. Hot dog. Do we have a second to that motion? So we have a motion and a second. All in favor signify by saying aye. Aye. I believe that passes unanimously, so then we can move on.
All right. I think the next thing on the agenda is some unfinished business, and I'll turn that over to our staff attorney.
Okay, at our last board meeting, one of the complaint number 2017-020591, I believe, was presented by Lindsay. And there was a question posed at the end of her presentation. And Lindsay, correct me where I'm wrong in the facts of the case. The respondent was an authorized dealer for a licensed alarm monitoring company. There was some dispute about the contract and who was responsible, and I believe the respondent submitted the contract for collections. Is that correct?
Right, so it was respondent sales rep. Remember talking about this one? The respondent sales rep goes into a home. The respondent is an electronics company, and then they're an authorized dealer of an alarm monitoring company. But the actual contract is that was negotiated by respondent sales rep is actually between the monitoring company and the consumer. So the question was, what's the liability, potential liability for the monitoring company? Is that right, Ashley?
Yes. That was the question posed at the last board meeting. And so I had done some research about the authorized dealer relationship, and it really comes down to a question of vicarious liability and apparent authority. The relationship between the authorized dealer, the monitoring company, and the responding company, it does not obligate the monitoring company for their actions because they aren't necessarily acting on behalf of that monitoring company. So the short answer is the monitoring company had no liability for the actions of that company. I did prepare a memo to give you all. I'm treating it as attorney-client communication, which is why it's not on the iPad for others to see, but I did want to give you that answer on the record.
All right, let me make sure I understand. Apparently, and I don't recall from the previous board meeting, the situation. Apparently, there's some question as to whether or not the monitoring company had a liability with regards to actions of the respondent company.
Correct.
And I would guess from that the respondent company had done something inappropriate, and assumably the complainant had a complaint back against the monitoring company and said, well, they were an authorized agent, therefore the monitoring company was responsible in some fashion. Was that the question?
It was their complaint was actually against the electronics company. So the monitoring company wasn't mentioned within the complaint, and there was never a complaint opened against them.
And part of the reason for that was I think the monitoring company actually did release the complainant from the contract. And then that electronics company apparently sent that contract for collections, and I think that's how the board saw to question whether or not the monitoring company had any liability. That was all I had.
All right. I don't see that there's any particular action that the board needs to take, that was a report you made for our information then.
Right, based on the question you all posed at the last meeting.
All right.
Okay, I believe the next thing on the agenda is new business, and only thing I have is that Mark Amick and Phyllis Patrick will be attending the, was it TNESA? Because we'll be, Sean and I will be preparing for another board meeting, and then we do have on September the 15th in Pigeon Forge would be the seminar that we have invited all the alarm contractors, locksmiths, private investigators, and security personnel to attend. It will be sessions, one in the morning, one in the afternoon. There are still some rooms available if anybody's interested. We'll be given at the state rate as well. Like I said, the last session for this year, I don't know when we will have another one. It is going to be actually onboarding, and we will be applications at this meeting. All applications are the same when you're onboarding, but we'll be actually there demonstrating how to do this for your registered employees. And talking about other things that are going on, but it'll be all professions that we do regulate this year. Hope everybody can attend.
Okay, is that all of our new business then? Basically was an announcement. Is there any other business that the board needs to conduct?
Are we supposed to attend the T&E? Involves the state board.
But if you do attend, you'll be giving continuing education. It's just going also of the onboarding.
Just point out that you're not there if you don't go.
I wouldn't do that.
If you go, you get 10 CEUs just to sit in and listen.
Socially ostracized.
I think I was a little late coming in one time and I got pointed out.
I did. Oh, I am just so bad. I'm sorry. That's the way they do me at these meetings.
All right, is there any further business for our board before we adjourn? All right, if there's none, then we will declare ourselves adjourned. Thank you for your participation.